I think we're ready to resume now. Mr. Singh.
Good afternoon, my lord. Thank you, my lords and my ladies. So what I'll do is I'll begin with a brief summary of the respondent's case. I will revert to the procedural point raised by my Lord Sales at the end of this summary. So just to begin with, we do not dispute that the tribunal's decision to release the appellant on bail was a judicial decision. We do not dispute that court and tribunal orders must be complied with whilst they are extant. They cannot be ignored, and parties must act consistently with any order. We say that in this case, the Secretary of State did not ignore the tribunal's order, but complied with it by releasing the appellant, as she was required to do by Rule 43 of the tribunal rules. We also say that the Secretary of State believed, as is clear from her correspondence at the time that's referenced in our case, that she was not acting inconsistently with the order by imposing restrictions on the appellant. Now, we've set out in our written case why we say there was, in fact, no relevant inconsistency between the tribunal's order and the Secretary of State's restrictions. If you agree with us on that, there's no need to take matters any further. If you're not with us on that, and you find that the Secretary of State did act inconsistently with the order, the tribunal's order, our submission is that that does not matter if the tribunal's order is void ab initio, because then it's treated as never having existed. So in my submission, the real issue in this case, and I will come back to the procedural point, but the real issue is the tribunal's order void ab initio, or is it only voidable, so invalid prospectively from the point it's declared to be so, or even not invalid at all? Now, I'm still on the summary here. So the appellant and the intervener say that a tribunal order cannot be void ab initio. Our case is that it can be, and it was in this case, and that the Court of Appeal was correct to find that it was. So when I get on to my main submissions, I'll focus on the void ab initio issue in two stages. So the first stage will be, can a tribunal order be void ab initio? And the second stage is, was this one, the one in our case, void ab initio? Now, if you were to find that the order was valid or only invalid prospectively from the point of declaration, then the effect would be that anything the Secretary of State did in the restrictions that was inconsistent with the order would be invalid. So my plan is to address you on the void ab initio issue, and the learned junior, Mr. Duffy, will then respond to the arguments against us on so-called relative nullity and Article 5. But of course, before I get to that, let me revert to the procedural point raised by Lord Sales. Now, it has never been said against us by the appellant that it was procedurally impermissible for the upper tribunal and for the Court of Appeal, a court of unlimited jurisdiction, to consider the validity of the bail order when deciding whether the Secretary of State's restrictions were lawful. So it's not a ground of appeal by the appellant that the Court of Appeal had no power to make paragraph 3 of its order at EF 217. Now, my Lord Sales raised that point today, and the appellant has somewhat opportunistically latched onto it, as we can understand. But you only need to look at any of the submissions that the appellant has made from October 2016 onwards to see that the appellant has never raised that point. So if that point is going to carry any...
Mr. Singh,
yes.
This case has been characterized by utter confusion. That's the impression I have. This court is going to have to try to clarify matters, to explain where people have gone wrong. And if part of their going wrong is the very first sentence of the Court of Appeal's judgment, where they say what the issue in the appeal is, if in fact that wasn't properly an issue in the appeal at all, the court is going to have to make that clear, because otherwise we're just persisting in this cloud of confusion that there has been up until now. Even even if the appellant hasn't taken the point, the court is going to have to clarify.
I understand that, and I was only building up to the point that because that point has only emerged today, in my submission, it would only be fair to allow the Secretary of State an opportunity to make written submissions to respond to it. I can give you very brief submissions now, but we're in no position to respond to it fully. I see my Lord Sales' hand is up. I'm not sure if I meant to stop there.
I was waiting for you to finish off for a convenient moment. But I mean, it goes a bit beyond whether the Court of Appeal had power to do anything, because if the matter had been raised by a judicial review proceedings brought by the Secretary of State herself, a whole range of issues would then have been addressed directly by the judicial review court, including, for example, the exercise of discretion in relation to what remedy should be given. None of that has ever been in play. So, I mean, speaking for myself, it does seem to me to be really quite a fundamental problem with the case as it's being presented by the Secretary of State, that she never sought to challenge the FDT's original order.
So, my Lord, the only preliminary observations I can offer now, from having been able to briefly think about the point over the short adjournment, is that as far as I'm aware, there is no hard and fast rule that a court of unlimited jurisdiction has no discretion to consider the kind of collateral attack on an earlier decision that we see in this case, when no challenge to that decision was made at the time. There's no firm rule to that effect, despite the fact that it's, of course, more preferable for the decision to have been challenged at the time. And there may also be a point that if it is going to be said that the Court of Unlimited Jurisdiction has no such discretion, equally that point should be made to that court at the time. Malena Jr., Mr. Duffy and I have briefly skimmed the authorities of nearly 2,000 pages over the short adjournment, and there is a reference to something Lord Diplock said in Isaacs, I think it's EF 796. So those are just preliminary observations, and in order to assist you fully, we of course understand that the court needs to consider the point, but we say we would need to be given an opportunity to research the point, because our view is it's not straightforward. So the experienced upper tribunal judge didn't think it was an issue, neither did the Court of Appeal, neither did any of the parties' representatives. So it may be a slightly more nuanced point than we think at the moment. So that's my only point, my lords and lady. It's just, please, could we have an opportunity to put written submissions in on it so we can consider it in more detail?
How long do you want?
However long you will give us, my lord, whatever is convenient for you.
Well, if we were to give you 14 days, would that be adequate?
That's completely fine, Lord.
And if we were to allow the appellant and the intervener a further 7 days thereafter, would that be adequate? Okay.
Thank you very much.
Very well.
So, my lords and lady, I was now going to deal with the first point, which is, can a tribunal order be void ab initio? And before we start getting into the authorities, I'll just say what our position is, which is, well, the answer is yes, a tribunal order can be void ab initio. Orders of bodies of limited jurisdiction other than the FTT have been held to be in effect nullities. So I'll take you to Re McC, but what happened in that case was that the House of Lords held that the failure to observe a statutory condition precedent meant that the decision of a magistrate's court was without jurisdiction or in excess of jurisdiction. It was not because of a procedural breach, as my learned friend Miss Weston suggested. I'll come on to that case. Now, in Dennis and Dennis, now I understand it could be said Dennis and Dennis is only a kind of family court decision. It's a single one-off decision, but it was applying the Court of Appeals decision in Manchanda. And what the court did in Dennis was to find that an order of the county court could be held to be void ab initio, and applying Manchanda, that was on jurisdictional grounds, again, not because of a procedural breach. My learned friend, Mr. Hussain, referred briefly to Beck, which I'll take you to. That suggested that the order of a Crown Court made outside its powers may amount to nothing. And in Privacy International, which my learned friend Ms Weston briefly alluded to, this court held by a majority that a decision of the Investigatory Powers Tribunal infected with any error of law was a nullity. Now, the decisions of all these judicial bodies, the magistrates, the county court, the Crown Court, and the IPT, can be treated as nullities on the basis of jurisdictional error. And I say there's no reason in principle why the first-tier tribunal should not also be included in that list. So that just prefaces the submissions I'm making on this issue. And what I was going to do now was take you to Remix C. So, okay, so Remix EF9.
Before you go there, Mr. Singh.
Yes, I'm sorry, my lord. Sorry, I didn't see your hand up.
If you're right on that submission, does it follow that non-compliance with the order is retrospectively excused when it's found to have been void ab initio?
Yes.
It does. And so therefore, although you have to comply with the court order, that's only if you choose to, because if you're confident enough that you'll be retrospectively excused, then that doesn't amount to very much, does it?
Well, my lord, you have to comply with it during its currency. You have to. The case has established that. Now, if it happens to be that it's declared void ab initio, that simply means it's treated as never having existed. But that does not excuse a party from having to comply with it whilst it is in force and before any such declaration is made.
For all intents and purposes, it means there could be no legal consequences attached to your non-compliance in that case.
It does mean that, my lord, yes, because it's treated as never having existed.
That's very nice then, isn't it? But that means it's completely wrong for you to say that, that there's a true obligation, absolute obligation to comply. It isn't absolute. It's only an obligation unless and until you're found to have been excused.
So unless and until any such declaration is made, you have to comply with the order, my lord. The party has to comply.
But then it turns out that you didn't have to after all.
It could turn out that could turn out to be the case that if there were any non-compliance, it's retrospectively treated as having no legal consequence. That could turn out to be the case. But a court making a declaration of void ab initio would be aware of that, as a court bill was in this case. I'm sorry, my Lord Sales, sorry.
Yes, I wanted to put to you so you can deal with it, that might it not be said that you're confusing two different points? One is whether someone has an obligation to comply with a court order unless and until it's been set aside by a court of relevant jurisdiction. And the other is, if it is set aside, what are the consequences that attach to what has happened in the interim, as to which there may be a range of different points that apply, depending on precisely what the consequences have been and the degree to which the unlawfulness, as on this hypothesis has been found, has had an effect on bringing those into being. Whereas you seem to be saying that at the second stage, void means void for all purposes, and that undermines then, in effect, the obligation at the first stage to comply with the order.
Lord, there is some case law in the administrative law context that if, for example, third parties are affected by the order before an administrative order is declared to be void, that may have consequences, but that's never really been kind of developed through. So there's still this conflict between, on the one hand, a school of thought that says, look, it's void ab initio, it's void, it's treated as never having existed, and it has no effect whatsoever. And then another school which says, actually, it may have effects in particular cases, depending on the facts. Now, in our case, I say the cleanest solution is void ab initio. I can't think of any kind of other stage which would, with the order still being treated as void ab initio, but for some reason the Secretary of State's, if there were any non-compliance, to still be regarded as having some legal consequence. There were no third parties.
Let me put two possibilities to you. One is, if one had gone down the judicial review route and judicial review had issued in relation to the FDT's order, which it didn't, one might then address the position from the point of view of the Seneji case, which looks to parliamentary intention to try to arrive at a conclusion as to what the interim effects of an order now found to be unlawful might have been. And the second way that that sort of problem gets dealt with in the administrative court is through discretion at the relief stage, where again, the court can have regard to reliance by third parties, and if there has been some, all relief in the administrative court is discretionary, and it can refuse relief. But again, there was no possibility of that happening here because no judicial review claim was brought in respect of the initial order made by the judge.
But then the effect of that would be, my lord, the Court of Appeal could have said, even though we're making a declaration, even though we're declaring this void and a nullity, it is still to be treated as having some effects prior to the declaration. The Court of Appeal could have said that. So it's not the fact that there was no judicial review doesn't mean that the Court of Appeal or this court now is deprived from the ability to say that we are still going to treat this void order as having had some consequences in the meantime prior to our declaration. So the court can still do that, my lord.
But as I understand it, the court didn't understand that all these questions arose because it wasn't facing or dealing with a judicial review claim. It just wasn't.
No, but the Court of Appeal did know that there would be consequences of the void ab initio declaration. They did know that. And in fact, some arguments were made to them that the void ab initio would not be appropriate. So
Yes,
they did know that, yes. So, my Lords Mayor, I was now going to move on to Re McC, if this is a convenient moment. And Re McC is at EF 911. So just to summarize, I don't think I'm going to have time to actually take you through kind of various passages of all these decisions. So just to summarize Re McC, what happened is that 3 justices of a juvenile court breached a statutory condition precedent by sending an unrepresented defendant who had never previously served a custodial sentence to a training school without informing him of his right to apply for legal aid. And the House of Lords decided accordingly that the justices had acted without jurisdiction or in excess of jurisdiction, leaving it open to the defendant to sue them for false imprisonment. So I would just ask you to just quickly go over the held note on 9.1.12 up to E.
The head note, Mr. Singh, seems to me to confirm what I interpreted the case, because I looked at it, as given your reliance on it, as turning on the true, what is the correct interpretation of a section of a Northern Ireland statute since repealed. And there's no wider...
What is the correct... Well, in my submission, my lord, it does, because the point here was that if there is an act in excess of jurisdiction, the order is treated, the decision is treated in effect as a nullity, and that's the way the European Court of Human Rights described it in the Benham case, which I'm going to take you on to. So the way that the European Court described it was, well, in English law, as we see from Re McC, if an act is taken in excess of jurisdiction, then it's treated as a nullity, essentially, as having no effect.
That's true on this case for the purposes of Section 15 of the Act and the ability to sue the magistrates for damages.
Yes.
It doesn't establish any wider proposition about the meaning of jurisdiction in any other context.
No, it doesn't, my lord, but it does give an indication that if there is an excess of jurisdiction, the Act will be treated as a nullity. The Section 15 itself is at 917. That's just a bit to do with legal aid. And the provision concerning jurisdiction is just over the page, my lord. That's at 918 towards the bottom. That's Section 15 of the Northern Ireland Act. Just if you want to have a look at that. In terms of the important passage from the judgment of Lord Bridge that I'd ask you to highlight, you may not have time to read it right now, but it's EF 934 it's EF 934H to EF 935F. And when you look at that, what you'll see is that the focus of Lord Bridge was very much on deciding whether the justices had acted without or in excess of jurisdiction. His focus when deciding that question was very much on the language of the statutory provision and its clear meaning. And we say, my lords and ladies, that is a clue to what should be done here, is to look at what the statute says, look at what paragraph 22 says, and then decide whether whatever the first tier tribunal did was within the jurisdiction, within the powers granted to it, or outside. And we can see that approach in all of these other cases as well. Just for your note, I would ask you just to not look now, but just make a note of 9. I'm sorry, my Lord Reed, I think you may be saying something, but I can't hear you.
Yeah. Carry on, please, Mr. Singh.
Oh, I'm sorry. So just for your note, 937B2E, Lord Templeman, I would just ask you to have a look at that. And I referred to Benham, so maybe I should take you to that briefly. That's tab 7 of the authorities bundle. It's EF, it begins at EF 673. And again, just to summarize the case, it concerned a case of a man imprisoned by the magistrates court for non-payment of the community charge. And there's a discussion in the case of how acts of magistrates courts in excess of jurisdiction are regarded as null and void from the outset in English law.
This isn't a decision. I don't think we're going to be assisted by decisions of the European Court of Human Rights on English law.
Yes, that's. I mean, you may want to have just.
Mr. Singh,
I'm sorry, my lord.
Do you accept that the problem with the order was capable of being put right by the order being varied?
No, my lord, because it's only possible to vary an order that is in itself valid. If it's void ab initio, it's treated as being there is no valid order to vary.
Well, that sounds like circular reasoning.
So on our submission, there was no bail order. There was no bail order to go to the tribunal to vary. So the variation assumes that there is a valid bail order.
So when right, okay.
Yes. So yes, my lord. Sorry,
I'm so sorry, Mr. Singh. I couldn't restrain myself at that point. But why isn't that a basis on which, if one got to a position where a court had set aside the order after a valid procedure and was looking to see what effect the order might have had in the interim, that one might say, following the sort of analysis that one sees in the Soneji case, that all the indications are that Parliament would not have considered a defect of this kind as something so fundamental as to deprive the FDT of jurisdiction to make an order which could be varied.
But, my lord, the Court of Appeal did consider that kind of point anyway, but in the context of whether the order should be treated as void ab initio, as having never had any effect. So Court of Appeal's view was it couldn't just be treated as a kind of minor defect, and it's possible to go to it's possible to vary it. That couldn't be done. It's not minor. It's fundamental because it goes to the immigration control point, which is it has to be surrender to the immigration officer, and it goes to the date and time point, which is how there's any kind of control over the bail. So it's so fundamental that there's no option other than to say it's void ab initio. And the Court of Appeal could have considered, my lord, when making that declaration, whether the declaration should indeed be void ab initio or voidable, because the Court of Appeal was aware of the tribunal rules. So we went through them and we said there were certain provisions that couldn't apply. So, for example, the slip rule relied on by my learned friend, Mr. Vaughan, we said couldn't apply. Court of Appeal didn't actually agree with us on that. They said, we think there should have been some way of going back to the tribunal, but their view was that the overriding objective would have been the answer, that the tribunal in the exercise of its overriding objective powers could have essentially recalled the ultra vires order. So that's the way they looked at it. But they could have considered these issues, my lord, when deciding whether the order should be void ab initio.
Yes, I see. Thank you. Yes.
Yes. So let's move on from Benham. So Dennis and Dennis, that's EF 715. So I'm not relying on this as a authority. It's more that it's a good example of the application of the Court of Appeal's decision in Manchanda. So, and again, I'm just going to very briefly summarize it. I don't want to spend too much time on it. But in this case, it's interesting what actually happened. So on the application of the husband, the county court issued a decree absolute before the earliest time for doing so under the relevant statute, as Milady mentioned. It also failed to serve the husband's application on the wife and failed to send her an authenticated copy of the decree as the relevant rules required. Now, what happened? The husband relied on the decree absolute to remarry and bring his new wife into the UK from Singapore. Now, if the decree absolute was void, it would have invalidated that marriage and had implications for the immigration status of the new wife. But nevertheless, the court found that it was void, applying Manchanda. If you go to 715, which I think you should already be on. Just one point of distinction here, and it relates to, back to something my lady said. I think my learned friend, Mr. Hussain, referred to the M&P decision, which was sent to us just after 11 p.m. last night, decision of Sir James Mumby. It's important to bear in mind that that case was not a jurisdictional case. So this case and Manchanda are jurisdictional cases. So they're about the breach of Section 9.2 of the Matrimonial Causes Act, whereas that other one isn't. And Wolfenden is also a jurisdictional case. And if you go to 724, just at the bottom, EF 724, that's just really for your note to give you an indication of what happened in this case. And 733, I think you've already been taken to it actually by my learned friend Ms. Weston, but it's really from E. That's quite an important point, that the court says, and this may be going back to my Lord Legate's point, that plainly any person who is a subject of an order of the court which turns out to be made without jurisdiction must obey it until such time as the order is declared by the court to have been made without jurisdiction or is set aside. Nothing in Hodgkinson, however, is inconsistent with the proposition that where a decree absolute is void ab initio, actions by the parties taken in the belief that the decree absolute was valid must themselves be of no effect. Now, Ms. Weston said it wasn't clear why this court did what it did. It is clear. The judge in Dennis applied the Court of Appeal's decision in Manchanda, which applied the decision in Wolfenden. I won't take you to either of those. I'll give you a reference for Wolfenden. It's tab 62. The facts were similar to those in Dennis, and the outcome was the same in that it was held that a decree absolute had to be treated as a nullity. So quite serious actions by the parties, marriage, bringing someone into the country, the immigration status of that person were treated as essentially all being a nullity. The marriage was a nullity. That has serious implications for the wife, but that didn't stop the court in Dennis from saying it was a nullity. And the key is that these orders, so the Magistrates Court in Re-McC and the County Court in the family law line of cases, they're treated as nullities when they're in excess of jurisdiction. And that seems to be the key point, because when we look at the decision in Beck, the same underlying point is being made. So if you go to Beck at 848, so this is a case where
I'm so sorry. Before we move on from Dennis,
yes,
reading it quite quickly. Was this looking at the right between the husband and the wife? The court was the court dealing with the question of, for instance, the marital status of the new wife for various purposes, or her immigration status? Or was it just dealing with the consequences as between the original wife and the husband for these purposes?
Well, all it was dealing with was whether the decree absolute should be held to be void. That's what it was dealing with, and it commented on some of the...
Void as between the husband and the wife. Is that right?
They didn't say for that purpose. They said void ab initio, and the court was aware that that would have consequences on the new wife as well. But that didn't stop the court from saying that it was void ab initio.
And can you just point us to the bit where the court deals with the consequences for the new wife?
Yes, I think that is the reference I gave you, my lord. That's 724. So if you go to 724 at the bottom, I think it's that. Or is it? No, hang on. I'm sorry, my lord. It's 719. It's 719 from just above D. That's when the court points out the respondent married Mrs. Victoria Dennis in Singapore, and then they point out that saying that the decree is void could have important implications for the immigration status of Mrs. Victoria Dennis.
Right, but they don't seem to be actually determining what those consequences might be in this decision.
No, they're not, my lord.
No, all right, thank you. That's all I wanted to check.
Yeah, I think the point is just that she came into the UK as a spouse on a spouse visa. She's no longer the spouse because a marriage is treated as basically being essentially a nullity because of the effect of the decree absolute. I think that's really what they're commenting on there, my lord. So I think I was just about to get to Beck. That's 848. And so, yeah, so this was a case where a restraining order was imposed on the defendant. If you go to paragraph 6, you'll see that this refers to section 5 of the Protection from Harassment Act. And it says, a court sentencing or otherwise dealing with a person convicted of an offence may, as well as sentencing or otherwise dealing with him in any other way, I think that was a crucial bit here, make an order under this section. And then if you go to paragraph 23, which is EF 856, you'll see that the submission made was that the judge lacked the jurisdiction to make this particular fresh restraining order. And then what the court said, Lord Justice Mance, was paragraph 26. You'll see that 3 lines down, the court says, we invited submissions from counsel as to whether the fresh restraining order could be said to be valid so long as it had not been set aside. And they point out neither, that's point A, whether the fresh restraining order could be said to be valid. And then at 27, the court says, as to point A, it seems to us that if the making of a restraining order was outside the powers of the Crown Court, then the decision to make one amounts to nothing, even though the order is only now being formally set aside. And then the points made, the Crown Court is a court of limited statutory jurisdiction rather than the court of unlimited jurisdiction to which the principles in Isaacs might apply. They do point out, though, that at the end, we say no more on point A in view of the very limited submissions addressed to us on it. So just important to bear that caveat in mind when it comes to this particular case. Now, my learned friend, Mr. Hussain, when he said there's been an indication that this decision was wrong, he was referring to the case of Kirby, and that's at 881 of the electronic folder. And again, just to very quickly summarize the facts. So Kirby concerned a non-molestation order made by the High Court. The defendant was convicted twice of breaching it. On the third prosecution, the Crown conceded that it was invalid because it was made on an ex parte application by a London Borough Council who had not been permitted to apply for it. The defendant appealed against the convictions on the ground that the non-molestation order itself was invalid. Lord Justice Singh dismissed the appeals. The case is really an illustration of the principle that court orders must be complied with unless and until they are set aside. So if you look at paragraph 13, which is, where is that? Sorry, that's
883.
I'm sorry, my lord, yes. Yes, so they remind themselves of the long-standing principle, and then Beck is considered at paragraph 20, and you'll see that Lord Justice Singh says about 3 lines down. That case concerned, we would observe, an order made by the Crown Court, which was described by Lord Justice Mance as being a court of limited statutory jurisdiction. That, of course, is not the status of the High Court, which, as we have observed, is a court of unlimited jurisdiction. And there's a suggestion also at paragraph 24. This point is returned to at paragraph 24. So the idea is the order of the High Court cannot be declared to be a nullity, but the order of a court or tribunal of limited jurisdiction can be. Now, at paragraph 22.
Yeah.
Yes.
Can I just be clear about what your case is exactly?
Yes.
Are you saying that there is no principle of English law that where an order is found to be to have been void, that it does not excuse failure to comply with the order in the meantime? Or are you saying that there is such a principle, but it only applies in the High Court, and if you're in the Crown Court, it's different?
So, my lord, we say that whenever an order is declared void ab initio, whether it's and that can only be done in the case of a body with limited jurisdiction. So, whether Crown Court, Magistrates Court, First Tier Tribunal, Investigatory Powers Tribunal, when that happens, the normal consequence is that the order is treated as having no effect. So, Lord, it doesn't matter which body of limited jurisdiction is. We say it's a general point that applies to all bodies of limited jurisdiction where they make an order that is void ab initio. I'm taking to these cases because these are illustrations of where it's been applied to different bodies. But we say it is an illustration of a more general point, that where a body of limited jurisdiction makes an order in excess of jurisdiction, it is possible to say that that is void ab initio. It depends on looking at the language of the statute concerned, considering what Parliament may have intended, but it can be done, as we see in these cases. So, paragraph 22, there's a reference here to the DPP and T case, and what Lord Justice Singh does. Sorry, he makes this point at paragraph 22. And then at 23, he refers to DPP and T. And at paragraph 26, what he says, he only goes as far as saying at 26 that there may be a conflict between the two. So a conflict between DPP and T and that kind of principle and what was said in Beck. But my response to that would be the DPP and T point is different. So that point is about obeying the orders of courts, including those of limited jurisdiction, whilst they are extant. Lord Justice Mance did not suggest in Beck that it was open to the defendant to ignore the restraining order. Rather, he considered what the consequence would be of a finding of nullity for anything that happened before the order was declared null. So I say there is in fact no conflict between Beck and those cases such as DPP and T, which say orders of courts of limited jurisdiction must be obeyed. Now, what I was going to do now was move on to the Supreme Court's decision in Privacy International. It's a very long decision, so I'm only going to be able to take you to a few paragraphs in it. It's EF 1698 tab 48. And the court will be familiar with this case. It concerned the determinations of the Investigatory Powers Tribunal. There was a statutory provision which said that except to the extent otherwise provided, such determinations and other decisions shall not be subject to appeal or be liable to be questioned in any court. The majority decided that determination meant legally valid determination, that any error of law, so not limited to a jurisdictional error, meant that any decision including a determination was not legally valid, was no decision at all, and was a nullity, and therefore the High Court's judicial review jurisdiction was not excluded in respect of any determination that was not legally valid. And the key paragraphs that I'd ask you to look at in your own time are from Lord Carnworth's judgment at paragraphs 104 to 109. And what is interesting is how the appellant answers Privacy International. So if you go to EF 141 to the appellant's case, at paragraph 40, you'll see that the appellant says it's noted that in Privacy International, the Supreme Court accepted that decisions of the IPT could be a nullity if they were erroneous in law, and on this basis would be amenable to judicial review. The issue of whether the determination was erroneous in law was in that case determinative of the High Court's jurisdiction to hear the judicial review. And then the appellant says, however, Privacy International has nothing to say about the different question which arises in this case of the legal status of the bail order between its making and the point at which it is set aside or quashed, or its invalidity established by the court. In the case of a court order, the answer is determined by the legal principles set out in this section under SM's primary submission. So that's not actually the question that arises in this case. It's accepted that whilst the FTT's order was extant, the Secretary of State had to comply with it. The issue is whether it can be declared to be void ab initio, thereby meaning that it is to be treated as never having existed, therefore rendering the question of compliance with it OTOs because there'd be nothing to comply with. I'm sorry, my Lord Sales, you have your hand up. I'm sorry.
It's my fault, but I am becoming confused again. At the time when the Secretary of State acted, the order was extant. It did exist,
yes,
and the Secretary of State disregarded it. So on what you've just said, she plainly acted unlawfully. Isn't that the end of the case?
No, my Lord, because part of our case is she did not, in fact, act inconsistently with the order.
Oh, I see.
So there's a part of our... I'm sorry, my Lord.
So subject to your points that she didn't act inconsistently with the order, as I'm understanding it now, you accept that she did act unlawfully.
Subject to those points. Well, no, if she wouldn't have acted unlawfully if the order is declared void ab initio.
Well,
then she hasn't acted.
That's the bit that I wanted to ask you about, because that's where I'm becoming confused. Because on the one hand, you say, order,
I understand.
Until set aside, order is binding, and the Secretary of State had to comply with it. And I point out to you, at the time the Secretary of State acted, it was extant, and on your submission, she did have to comply with it. And then you say, but later on, it was declared void, and she didn't have to comply with it. How do you reconcile those two things?
Well, she had a duty to comply with it, but once the order is declared void ab initio, it's treated as never having been in existence. So it follows that there's nothing to comply with. So she can't then be treated as acting unlawfully. She did have the duty, but if surely we're looking at
whether she. So I'm so sorry to interrupt, but surely we're looking at whether she acted unlawfully at the time she acted. And on your submission, she did act unlawfully at the time she acted.
Well, the actual submission is she did not. But if you're against us on that, if you find there were an inconsistency, then she did not follow her duty to obey the court's order. But effectively that effectively does not matter if the order is then held to be the court's order is then held to be void ab initio. That's the point, my Lord.
All right, thank you.
That takes us back to Lord Leggett's point from 10 minutes ago. But what's the value of the rule that you must obey court orders if there's no conceivable sanction if you don't, because everything flies off as soon as the order is held to be void.
But my Lord, that's a rule of law point, that if the order's made and it's in force and there hasn't been a declaration that it's a nullity, every party has to abide by it. They have to. But if it then becomes the point that it's treated as never having existed, then one could say, well, why then should parties still be held to be legally liable for things they did which are contrary to an order that is treated as never having existed? I'm sorry, my Lord, I've noticed that my lady's hand is up. I'm sorry, I've gone on a bit.
I think it's a bit confusing to talk about the Secretary of State complying or not with the bail order. I think the question is whether she had power under paragraph 2.5 to issue the notice of restrictions. Now, I think that it must be accepted that if there's a valid bail order in place, then she does not have power to make restrictions under paragraph 1.25 of Schedule 3. So the question is, did she have power on the 30th of July to issue the notice of restrictions? If she did not, then your case must be that once the bail order is removed, somehow those at the time ultra vires notice suddenly has vires and is enforceable, which then raises the question, well, what about SM, the appellant, if there had been inconsistencies between the bail order conditions and the notice of restrictions, which of them is he supposed to comply with? Because if it turns out that the bail order is invalid, suddenly she retrospectively had vires to make the notice, so he ought to have complied with those and not the bail order. But if the bail order is valid, then he ought to comply with that, because she had no vires to make the notice of restriction. So it's really him that's put in the predicament rather than Secretary of State, isn't it?
So, Milady, if the order was valid, that doesn't affect the Secretary of State's power to impose the restrictions, because the power comes from Section 2.6, which is EF 547. So she has the power to make the restrictions so long as the claimant, as long as the appellant is liable to detain but is not detained. So the power is not affected. You're right, there may be some restrictions which are inconsistent with the tribunal's order. That could happen. So my learned friends made the point about the employment restriction. Now, if he's in that position, so the appellant's in a position where he has a condition imposed by the tribunal and one imposed by the Secretary of State, he has to abide by the tribunal's condition. He has to, he's got no choice. It's a tribunal order. As the intervener points out in paragraph 21 of its case, he can take the risk of not complying with the Secretary of State's order, because he can act as if it's not valid. I mean, this is what the intervener says at paragraph 21. So he can decide, I'm not going to comply with it. And it's interesting that in one of the emails that we have from Mr. Ferner in the bundle, Mr. Ferner says, look, my client can take the view that he's not going to do this, and that's right. He is allowed to do that. He can make that risk assessment as far as an administrative order is concerned, but he has to apply. He has to comply with the tribunal's order. So the tribunal's order does trump anything that the Secretary of State's restrictions do, milady. If you want to have a look at the intervener's case, it's wherever that now. Okay, that's it begins at 193. And you'll see that at paragraph 21, what the intervener says is it's 206. By contrast with the position in relation to court orders, it is open to an individual to disregard the presumption of validity and proceed on the basis that the relevant administrative act or subordinate legislation is unlawful. That's correct. That is, and there's authority cited for that. So the tribunal's order trumps whatever the Secretary of State's restrictions say. So I think that's the answer to the problem of hierarchy, lady.
Mr. Singh, could I ask you a question about that? Because
yes,
we have two cases cited there. One is Marcel. We've looked at Marcel. I mean, Marcel affirms the basic position that an administrative act is treated as valid unless and until set aside. Boddington is dealing with a point where the first time the matter comes before the court with the person who's said to be bound by the rule in a position to challenge is when they're prosecuted. And so there the individual is before the court arguing at that time that the rule should be treated as invalid. But in our case, the issue as to the conditions of bail were precisely the point of dispute between M and the Secretary of State before the FTT Judge Narayan, and were determined by him. So it's not a question of waiting to some subsequent occasion when the issue can be debated between them. It has been debated and has been determined by Judge Narayan.
But that's what I'm saying, my lord. What the appellant would do then is abide by the tribunal's order. He would abide by that. If the Secretary of State has the Secretary of State's conditions came after the order, my lord. That's the other point to bear in mind. Judge Narayan made his order he said, I'm going to, according to Mr. Ferner, he said, I'm not going to prohibit the appellant from unpaid employment. So he said that. And then what happened subsequent to that, later on, is that the Secretary of State issues her restrictions. So they don't happen simultaneously. They happen slightly later. Now, if it transpires that there's something inconsistent in the restrictions, what the appellant must do is follow the tribunal's order. He has to do that because he is allowed to take. Yeah.
How can you argue they're not inconsistent? The Secretary of State's just lost the argument in front of the FDT and promptly goes back to the office and issues an order giving effect to the submission which the court rejected.
So, my lord, the argument on the paid employment thing, that's really just a technical argument we make about it's not before this court. That's just a technical point, but we accept that if you look through that, there is an inconsistency. Of course there is. We accept that. But the only other point is to do with the paid, the reporting. Yeah, and we're not sure whether it's actually correct that the Home Office presenting officer said it's okay to for there to be no reporting condition, because in the bail summary he included both a reporting condition to the immigration officer and reporting to the offender manager. But if you were to find that actually the presenting officer did accept that there should be no reporting condition, then that would be another inconsistency. That's right. So I think my Lord Leggett has his hand up. Sorry, my lord.
Just to test what you're saying, Mr. Singh, we know in fact the Secretary of State did release the appellant, but suppose that she'd not. Suppose she'd taken the view this was an unlawful order issued in excess of jurisdiction, so I'm not going to follow it. You're saying, well, she'd be acting wrongly then, but then she goes to court to challenge it, and it's found that it was actually an order made in excess of jurisdiction. He seeks damages for false imprisonment because he wasn't released in obedience of the order. You say that claim fails because he was vindicated when it went to court, and therefore her refusal to follow the order was vindicated, and she never, although you say she had to abide by it, that amounts to nothing actually, because having been held to be invalid, the consequence is that you didn't have to abide by it. That's your argument.
So, my lord, if the Secretary of State refused to release the appellant, as she would be required to do under Rule 43, in the face of a tribunal order, that would be a judicially reviewable abuse of power. So the appellant would have a remedy at that stage. The appellant could take the Secretary of State to court via judicial review and say, we have this order, there's been no declaration that it's a nullity, and you are not abiding by it, and therefore you're abusing your power. So the remedy will kick in at that stage.
Once there is a declaration it was a nullity, all that falls away, and it's all right after all for the Secretary of State. On your submission.
If the Secretary were to do that, my lord.
Yes.
If that's of course not this case. If that were to happen, then my submission would be if she did that, my lord, my submission is that the appropriate remedy would be for the detained person to make an application for habeas corpus or issue a judicial review application in order to secure his release.
Yeah, but he has to get in there first. He has to get in there first. If it's decided that the order was unlawful, well, all his attempts don't count for anything on your submission because it was a nullity, and so the Secretary of State is let off the hook. She didn't have to. It now turns out she never had to abide by it. She might have thought she did, or other people might have thought she did, but it's all well and good.
Well, my lord, you say he has to get in there first, but in practice, he would have the option of making the application. You know, when the Secretary of State refuses to detain him. The only reason we get to the point here, the Court of Appeal making the declaration it did about the order being a nullity, is that quite a considerable time after he is released, it's raised in judicial review proceedings issued by the claimant, then claimant, now appellant. So we say in practice it would be
corpus, your client could defend the application and raise, like in Boddington, in the context of that, the argument that it was a nullity, so he can't be released. And that would be a good defense.
She could do that. But if it were a nullity, my lord, if it were a nullity, it would have to be made in excess of jurisdiction. So we say, my lord, there's no difficulty with the court then saying, well, because it's a nullity, well, the appellant can't be released on bail, the detainee can't be released, because it has been made outside the powers given to the tribunal by Parliament. So it has to be a fairly serious thing, my lord, for it to get to the stage where it's declared to be void ab initio. I don't know whether it's okay now just for me to go on to the next point, because I think I might be running out of time. But yeah, sorry, it's where were we? Okay, so yes, if we just deal with paragraphs 35 to 39 of the appellant's case, so you'll see that this is from EF 140. You'll see that this is all under the heading, as is paragraph 40, court orders found to be unlawful and not void ab initio. So I'm just going to quickly deal with these. So paragraph 35, it is inherent in the Isaacs principle that a court order, once deemed to be unlawful, is not void ab initio, even if made in want of jurisdiction. My answer is no. That principle is that court orders must be obeyed unless and until they are set aside. It does not say that they cannot be declared void ab initio. The next point, paragraph 36, this was made clear by Lord Dyson in the KW case at 22. When they say supra at 22, that's EF 139. No, what Lord Dyson said was that an order would still be binding even if there were doubt as to the court's jurisdiction to make the order in reliance on M and Isaacs. He did not say that the order would still be binding if there was in fact a finding by a court that it was made outside the court's jurisdiction. The next point, paragraph 37, were the position to be otherwise, the unlawfulness of the High Court orders at issue in Chuck, Haddington, Isaacs and M could have been relied upon as a defence of the contempt of court proceedings. No, they could not, because the issue of excess of jurisdiction does not arise with High Court orders, as the High Court has unlimited jurisdiction. Those cases are about a different issue in any event, whether a party could simply ignore a court order. And then paragraph 38, the point that orders of the Crown Court cannot be a nullity was made by Lord Scarman in Kane on a different basis, namely that the Crown Court was a superior court of record and that would undermine the authority of the criminal law if orders made by the highest court of trial in criminal matters could be regarded as nullities. You don't actually have the case of Kane in your bundle, but it's the reference is 1985 appeal cases 46 at 55. And what you'll see when you look at that is indeed referring to a superior court of record. And Lord Scarman also said the issue was not really one of jurisdiction, because he said this, well, in that case, the Crown Court was in the capacity of being a superior court of record. So it had unlimited jurisdiction to hear any matter that came before it. And of course, the first tier tribunal is not in the same position. And then paragraph 39, while it is accepted that decisions and orders of the FTT can be subject to judicial review and can be quashed, even the quashing of its orders does not result in their being void ab initio, as is generally the case with acts of administrative authorities as set out below. That is not correct and is not the approach the majority took in Privacy International. And then if you have a look at footnote 5 to paragraph 40 of the appellant's case, there's a reference to Re McC, and that's characterized as a case in which there's been a fundamental collapse in fair procedure. The appellant says it's a case where he was wrongly convicted pursuant to a serious procedural irregularity. This was on the basis that the justices had acted in excess of jurisdiction, a statutory ground which prevented the case falling foul of a statutory bar on such claims. SM does not consider that this case affects his analysis, since its conclusions are confined to the particular statutory scheme in question, and in any event rely on a distinction between jurisdictional and non-jurisdictional errors, where there was egregious procedural error, which does not shed light on the consequences of the particular defect in the bail order at issue in SM's case. Now, that's a misreading of Re McC. The magistrates did not sentence the defendant pursuant to a serious procedural irregularity, but as a result of a breach of a statutory condition precedent of the kind we see in the present case. So we say, my lords, my lady, that there is no real doubt that first-tier tribunal orders can be declared to be void ab initio. And I say that would make, the fact that they can be, would make particular sense in the case of paragraph 22 1A, where the same power is exercisable in the same terms by either the Chief Immigration Officer or the first tier tribunal. The consequence of the error we see in this case should be the same, regardless of which of the CIO or the FTT makes the error. Now, my Lord Burrows asked Miss Weston, do your submissions vary depending on who purports to grant bail? They do, because if the CIO had made the same order as the FTT made in this case, Miss Weston would be saying it is capable of being held to be void ab initio. So those are my submissions on whether a tribunal order can be void ab initio. I was now going to address you for a few minutes on whether the order in this case was void ab initio. So I'm just going to move on to that issue now in the time I have left. I actually don't know if you've been taken to paragraph 22 so far. I think my learned friend Miss Weston may have briefly referenced it at the beginning of her submissions, but it may be worth just turning that up at EF 504, because my submissions are made by reference to it. And what you will see is that paragraph 22(1) provides that a detained person may be released on bail in accordance with this paragraph. So there's no power to release on bail other than in accordance with this paragraph, so paragraph 22. Paragraph 22(1)(a) empowers the FTT, the relevant body in our case, to release a person only if that person enters into a recognizance conditioned for his appearance before an immigration officer at a time and place named in the recognizance. Now, as the Court of Appeal indicated at 58, paragraph 58, appearance before an immigration officer and appearance at a named time and place are fundamental aspects of the grant of bail under this legislative scheme. Appearance before an immigration officer fulfills the essential feature of control of immigration detention bail by the immigration authorities. That's essential condition 1. And appearance at a named time and place is essential to bring bail to an end. That's essential condition 2. Together, they express the idea of surrendering to bail to an immigration officer. I won't have time to take you to it, but CAR Pakistan Court of Appeal decision, tab 5, EF 639 at paragraph 26. Now, those two essential conditions in paragraph 22(1)(a) cannot be conflated with the conditions referred to in paragraph 22(2). Paragraph 22(2) states, as you'll see, the conditions of a recognizance taken under this paragraph may include conditions appearing to the immigration officer or the first tier tribunal to be likely to result in the appearance of the person bailed at the required time and place. Therefore, paragraph 22(2) assumes that the two essential conditions in paragraph 22(1)(a) have been set and is directed at secondary conditions that are likely to result in those two essential conditions being met. Secondary conditions would be those of the kind set out by the Secretary of State in her bail summary that Miss Weston took you to at EF 382. Now, the purported grant of bail by the first tier tribunal did not include either of the two conditions essential to operation of bail under paragraph 22. Therefore, the first tier tribunal released the appellant out with the power given to it by Parliament to do so under paragraph 22. It clearly acted in excess of its jurisdiction in breach of what were in effect statutory condition precedents. So following the approach in Reem, C and the other cases I took you to, the order is a nullity. It's void ab initio. And I say the Court of Appeal was correct to declare that. I was now just going to, I noticed that my Lord Reed seems to be looking at the provisions. I don't know if there's a question that you wanted to ask me, Lord Reed. No, I'm sorry. So just, I was just going to address you very briefly on remedy. You'll see what we say about remedy at paragraphs 94 to 97 of our case. Now, what my learned friend Ms. Weston has said is that the appellant wants restoration of the relevant paragraphs of the upper tribunal's order. The only relevant paragraph would be paragraph 2, because paragraph 1 was never challenged by the Secretary of State. paragraph 2 declares that the appellant remains on bail granted by the first-tier tribunal on the 30th of July 2015. Now, if that purported grant of bail was validly made under paragraph 22, he cannot still be treated as being on that paragraph 22 bail, because as Ms. Weston accepts and says, he was transitioned onto Schedule 10 bail from 15th of January 2018. So we say the appellant hasn't actually identified any remedy of any use to him. So, my lords, my lady, unless you wanted to ask me anything about those points or any more general points in the case, I was now going to pass on to my learned junior, Mr. Duffy, who's going to address you on some points to do with relative nullity and Article 5. So if this is a convenient point, my lords and my lady, I will pass on to Mr. Duffy. Oh, I'm sorry, my lady. My lady has a hand up.
I just ask, I mean, isn't the remedy to say that the notice of restrictions is quashed to ensure that there can be no question in the future of criticising or taking action against against the appellant for failing to comply with the notice of restriction? Wouldn't that be the appropriate remedy if we held that the bail order was not invalid ab initio?
My lady, there are no more notice of restrictions. They were all done away with. Paragraph 2.5 was amended from the 15th of January 2018. So there isn't that anymore. Now it's just bail and conditions of bail. And as far as the two specific restrictions that were complained of are concerned, there is now a valid reporting condition. My learned friend Ms. Weston confirmed that the appellant is reporting every month, and he is permitted this to do this voluntary work. So again, it's of no use to him to say that that they were being. Sorry, my Lord Sales, you have your has his hand up. I'm sorry.
Well, as I understood the point of my lady's question, it's that you can go back in time and prosecute someone for breaching the obligation that they be a prisoner unless the bail order was issued by the FTT was valid. So if that's right, then there is relief that we can usefully grant in this case if we don't accept your submissions, isn't there?
He did not. He didn't breach the notice of restrictions, my lord. He didn't breach them. He
Well,
did. He did, in fact, not. Well, there's no evidence he ever breached them.
No,
well, we know
but...
he. We know. I'm sorry, my lord.
The evidence might be forthcoming tomorrow. You suddenly find that well, as my Lord Legate has said, he's been at liberty. He has been breaching it. We know that. It's just a question of whether he's going to be prosecuted for it.
You might find out he did spend an afternoon in the charity shop. I mean, you know, it matters in theory, even if not in practice, doesn't it?
Yeah, in theory. I mean, in practice, it's not going to happen. But in theory, I accept that, Lord. That I think we can leave it at that. So, my lords, my lady, did you want to ask me anything else at all? No.
Not.
Okay.
Thank you very much, Mr. Singh. We'll turn then to Mr. Duffy.
Thank you, my lords and my lady. Just before I move on to talk about the two issues that my learned leader, Mr. Singh, has indicated that I will cover, I just wanted to pick up on 2 points that have been raised. And the first is this question that my Lord Reid asked about how one reconciles what does appear on the face of it to be a tension, at least, between the idea of void ab initio status upon declaration of nullity and upon the obligation to adhere to a court order, to respect a court order in the period before it's set aside or otherwise declared invalid. And I would suggest that there is a subtle distinction between the two scenarios, and it's best explained perhaps by looking at the conduct required of someone in response to a court order versus the validity of that court order. And my Lord Reid asked, well, what's the value in saying, well, you've got to follow the court order if by the end of the exercise, in fact, the order is declared invalid, and therefore you could have just ignored it from the start, and wouldn't that encourage decision makers just to paraphrase, to hedge their bets? Well, the value is that due to the norm, which no one in these proceedings disputes, that court orders are to be obeyed. If they are not obeyed, then the individual has the immediate remedy, and to take this case as an example, of an application for judicial review, which is what happens in this case. The court on judicial review would then be expected and would determine the lawfulness of the impugned decision. And as part of that process, ordinarily, one might not expect this, but in an appropriate case, the assessment of the lawfulness of that decision will be intertwined with a question, perhaps, as in this case, of the lawfulness of what I might describe as a countervailing court order. And it's only in those circumstances, and where the court went on judicial review to then decide that the court order was void ab initio, that the Secretary of State, or whoever the decision maker may be, would ultimately never have had to comply with the order as a matter of law, as a matter of validity. In other words, the validity of the order never existed. So that's just one point I'd make about that. And then,
Mr. Duffy, sorry, before you move on to your next point, I confess to a degree of confusion. It probably is my fault again in that submission. You say that the assessment of the lawfulness of the matter which is under judicial review, so in our case, the restriction notice, will be intertwined with the lawfulness of the countervailing court order. Sorry, the underlying FTT decision will be intertwined with the lawfulness of the countervailing order to be made by the court. Is that what you said?
My Lord, there may be some confusion. What I was saying was, in the event that a decision maker made a decision that was flagrantly in breach of a court order, i.e. didn't follow through on the obligation to respect a court order, then on the judicial review of that decision, on the basis that it was an abuse or whatever the ground for judicial review would be, the court would have to consider whether it was in fact the case that there was a conflict with a valid court order, or it may have to consider that point. Now, in a case where it does consider it and it reaches the conclusion that the court order was in fact invalid, then it is.
But why would it? Here, as I understand Mr. Singh's position, there is a valid court order. It's the FTT order of Judge Narayan. So the court doesn't have to consider whether that's valid or not. It proceeds on the basis that it is.
No, it doesn't, my lord. It proceeds on the basis that parties have to respect it and follow it. It doesn't proceed. It doesn't have to declare that it's valid or to simply go along with the idea that it's valid if there is a fundamental reason, as we say there is in this case, for saying that it is invalid for want of jurisdiction. And if that is the case, then there's nothing offensive to the rule of law about declaring that and about declaring the effect of that to be a retrospective effect.
Right, I see. Thank you.
Thank you. I'll move on, my lords and my lady, to the points about relative nullity and, if there's time, Article 5. The appellant's position on nullity as a relative concept is outlined at EF 156 at paragraphs 98 and 99 of their case, and it may just be useful to have a look at how that point is made on behalf of the appellant. Now, conspicuously, this is not a matter, as I understand it, that bail for immigration detainees places any reliance on or has pushed, despite the appellant's case being filed and served before its case was. But the Secretary of State's case on this issue rests on 5 broad submissions. 1, ultra vires decisions are nullities, not relative nullities. 2, ultra vires decisions are void ab initio, and that means they're not relatively void or voidable, but retrospectively null. 3, in terms of the scope for a relative approach to nullity, there is a qualitative distinction, and I'll take your lordship's relationship to some of the materials on relative nullity to make good this point. There is a qualitative distinction between jurisdictional defects and procedural irregularities. 4, some defects are capable of being viewed retrospectively as having some enduring legal consequences. We accept that. And 5, the context of personal liberty, which is relied upon by the appellant, adds, we say, nothing useful to the analysis in this case. And I'll then set out briefly why we say the concept of relative nullity is of no assistance to this appeal. In terms of submission 1, I'm not going to go over the ground that's already been covered by Mr. Singh. But we say that a decision reached in breach of public law considerations is a nullity and void ab initio, per cases like Anisminic, Boddington, indeed this court's judgment in Lumba as Secretary of State for the Home Department. Our second submission is the ultra vires decisions.
Mr. Duffy, I'm so sorry, I don't want to take up a lot of time, but are you going to say anything about the Soneji case? Because that was a case where there were defects, but precisely the conclusion was the order made was not void ab initio.
Well, my lord, I'm going to come on to, as part of my 4th submission, the situations in which that sort of approach is possible.
All right, thank you. I'll wait till then.
Thank you. Submission 2 is that ultra vires decisions are void ab initio, and we say that means that they are not relatively void or voidable, but that they are retrospectively null. And a useful place to start when looking at this debate over relative nullity versus what might be termed absolute nullity is Professor Craig's chapter on invalidity, which has been included in the bundle. And I'd ask you just to turn to the start of that chapter, which is at 2218, EF 2218. And he explains what is meant by void being a relative, not an absolute concept. He says in the first paragraph, if the decision maker had no power, then the decision should have no effect. And then in the 3rd sentence, void is, however, a relative, not an absolute concept, the meaning of which can be explained as follows. And if I can then move on to he then goes on to explain several examples of what he means by that. But if I could ask you to move to 2225, please. Professor Craig at point 24-002 and 22, and I'm sorry, my lords and my lady, that the copy here is not particularly easy to read, but Professor Craig explains that, and this is about 6 lines down from 24.022, the traditional meaning of the term void in the sense of retrospective nullity captures the natural conclusion that if a decision maker had no power to act, then the act should be of no consequences. And then he quotes from Lord Diplock in Hoffman LaRoche, and it's an extremely bad copy, or it's very small text, so you may struggle to follow that. But what Lord Hoffman says is at 1286. So I'd ask that you just keep a finger or a virtual finger in 2226 and go to 1286, please. And the passage, which I'll just leave your lordships and your ladyship to read, is the final paragraph on page 1286.
Can I ask you this, Miss Duffy?
Yes.
The passage you just took us to, Professor Craig, I'm surprised you told us.
I'm sorry, my lord, I can't really hear you, I'm afraid.
I'm sorry. In the passage you took us to in Professor Craig at 2225, he was saying that the traditional meaning of the term void captures the natural conclusion that if a decision maker has no power to act, then the act should be of no consequences. Fine,
Yes.
that's perfectly understandable. Now, in the present situation, the FTT clearly did have jurisdiction to deal with the issue of bail. And the problem with its order is that it failed to include certain necessary aspects of such a necessary components of a valid order. I would have thought that was something that could have been put right by going back to the FTT and asking it to amend the order. Is that right?
Well, my lord, we wouldn't accept that, and that may have been possible if the problem in this case had been some failure to attach a permissible secondary condition. So, in other words, one of the conditions under paragraph 22(2). Can I just ask you, my lord, to turn up the relevant provision, because this I hope will be a useful exercise. So it's Schedule 2, paragraph 22, which is on page EF 504. And we say a very important distinction between the condition, what you've described as one of the conditions at 1A, and the conditions at paragraph 2. And if you look at 1A, we say that the condition there is not simply one of the conditions that can be attached to bail, but a necessary precondition. And the reason that we say that goes back to paragraph 22. Paragraph 22(1), because it is clear that the persons who can be detained at subparagraph 1 may be released on bail in accordance with this paragraph. 1A then predicates the power to release, whether it's exercisable by the FTT or by the immigration officer, upon the entry into the recognising condition for his appearance before an immigration officer. So we do describe this as a jurisdictional issue, because what's happening here is Parliament is giving the FTT or the Chief Immigration Officer a power of release, but only if a certain precondition is met. And I describe that as a precondition, as opposed to the sorts of conditions that then may be included by the permissive language at paragraph 22(2). So that's the distinction.
I see. Right, thank you.
So in terms of my third submission then, my lords and my lady, in terms of the scope for a relative approach to nullity, there is, we say, a qualitative distinction between jurisdictional defects and procedural irregularities. In other words, ultra vires versus what might be described as voidable decisions. And what we say is that with jurisdictional errors or jurisdictional defects, the decision is outside the power of the decision maker, whereas with procedural errors, that depends, could depend on an analysis that might include whether the requirement was mandatory versus directory, whether it was waived or could be waived, and what might be the consequences of non-compliance with the condition. And I don't propose to take the court back to it But that distinction is noted by Professor Craig in his explanation at page 2220 of the bundle. And indeed, at that paragraph, he refers to what Lord Wolfe said in the case of Gianthan, which is an authority relied upon by the appellant at paragraph 91 of their case. And it may just be worth going to that, my lords and my lady. Paragraph 91, so it's at EF 154 of the bundle. And here, this goes, I suggest, to my Lord Sale's point about whether there is, in short, any flexibility over the consequences of a declaration of invalidity or of void, of a nullity. And this is Lord Wolfe citing a judgment by Lord Hailsham in London and Clydesdale Estates, and describing how in certain circumstances that sort of flexible approach might be applied and what considerations would be taken into account. But he says in the final sentence of that passage, if the result of non-compliance goes to jurisdiction, it will be said jurisdiction cannot be conferred where it does not otherwise exist by consent or waiver. Now, by taking you to that case and what I've said previously, it'll be apparent that I accept that there are some defects that are capable of being viewed retrospectively as having had some enduring legal consequences. It's not a new concept, but in our submission, relative nullity, or that sort of flexible approach to nullity, is appropriate in non-jurisdictional cases, non-jurisdictional defect cases, if I can call them that, where it can be used as a judicial tool to effectively iron out any unfair or otherwise intolerable consequences that might otherwise flow from a declaration that an act or decision is null and void. And that was how it was envisaged and neatly articulated in obiter comments by Lord Brown-Wilkinson and by Lord Slynn in the case of Boddington. And if I could take the court to that, it's at 1162 to 1163. Second line of the second paragraph. This is Lord Brown-Wilkinson. You see that about halfway down that paragraph. Well, I'll just start with the beginning. The Lord Chancellor, he noted, attached importance to the consideration that an invalid bylaw is and always has been a nullity. The bylaw will necessarily have been found to be ultra vires, therefore it is said it is a nullity having no legal effect. I adhere to my view that the juristic basis of judicial review is the doctrine of ultra vires. But he goes on to float the idea of a more flexible approach, because he says, I am far from satisfied that an ultra vires act is incapable of having any legal consequence during the period between the doing of that act and the recognition of its invalidity by the court. And here comes the rationale, my lords and my lady. During that period, people will have regulated their lives on the basis that the act is valid. The subsequent recognition of its invalidity cannot rewrite history as to all the other matters done in the meantime in reliance on its validity. And over the page, there is a similar observation by Lord Slynn. It's in the second paragraph, about a quarter of the way down. This may be the logical result and will no doubt sometimes be the position, but courts have had to grapple with the problem of reconciling the logical result with the reality that much may have been done on the basis that an administrative act or a bylaw was valid. And he refers to the unscrambling and how that may produce more serious difficulties than the invalidity. So there is room for that sort of relative approach. But we say that it's limited to those sorts of cases where there is the opportunity for a court to take action to regularise a situation that would otherwise affect third parties. Submission 5 is simply, my lords and my lady, that the context of personal liberty adds nothing to the analysis, and the appellant cites 2 cases in relation to personal liberty, and they're at 102 and 103 of its case at page 158, EF 158. And it's perhaps worth just considering these cases for another reason, because they go to the question raised by my lady, Lady Rose, about what happens if the the object of a court order on the one hand and the Secretary of State's restriction notice on the other, the individual finds himself in a predicament of having to choose between respecting an order and respecting an administrative decision by the Secretary of State. Well, it was said by my learned friend, Mr. Singh, that he should respect the order. And Evans and Henderson show the protection that would be afforded in that situation, because jailers or prison authorities in those cases could not be held liable for false imprisonment on the basis of detention that had been effected pursuant to an unlawful order. Once that order had been set aside, they were entitled to and expected to follow the order. So turning to this case, my lords and my lady, the relative nullity is inapposite, we say, because the defect in this case cannot be reduced to procedural irregularity. It was an ultra vires act going to jurisdiction, and what has perhaps been lost in the debate so far is that this wasn't some arbitrary requirement inserted at paragraph 1A that didn't serve any useful purpose. Its purpose is plain on the face of the provision: to ensure that someone being released from immigration detention, who in this case happened to be subject to an extant deportation order, having been convicted of very serious offences, to ensure some measure of immigration control. And without that, in this case, he would have simply been capable of being released without any follow-up being arranged with the immigration authorities. And it's no answer to that to say that he was due to appear before his offender manager for criminal justice reasons. There would still have been no immigration purchase, no immigration control upon his immediate future following release. My lords and my lady, unless you have any questions in relation to relative nullity, I propose very briefly to just touch on Article 5. We say Article 5 adds very little, if anything, to the analysis. The court will not require any summary of what it requires, but there's a useful brief summary for your notes set out by Lord Hope in Evans number 2, and you'll find that at EF 1912. Article 5 is deployed by bail for immigration detainees in 3 ways. One, as reinforcing the need to respect court judgments. Well, we say that doesn't need reinforced. 2, as an aid to the construction of paragraph 22(1)A, and 3, to underline the importance of non-arbitrariness in detention and bail decisions. On construction, we say that reading paragraph 22(1)A in the only, in our submission, conceivable way it could be read, which is to view entry into the relevant recognizance as an essential precondition, doesn't offend and needn't offend against anyone's Article 5 rights. Paragraph 22(1)A simply formed part of an immigration bail regime that didn't place any impediment, still less a disproportionate impediment upon the discharge of or the existence of powers of release. On non-arbitrariness, the appellant's paragraph 94, which is at EF 155.
Mr. Duffy,
yes.
Sorry, just before you
Lord.
move on from that.
Yes.
So what do you say about the dispute in the Court of Appeal between Lord Justice Haddon Cave and Lord Justice Underhill on the Article 5 point?
Yes, my lord, we don't seek to adopt the analysis of Lord Justice Haddon Cave in that stage. The strict and narrow construction principle we would submit or suggest is limited to the interpretation of measures designed to impinge upon liberty or limit liberty, not powers of release. So it's not of any useful application in terms of interpreting paragraph 22(1)(a). At paragraph 94 then of EF of the appellant's case, which is at EF 155, the appellant argues that it would be arbitrary and a breach of Article 5(1) for a grant of bail to be thwarted by a failure of the necessary paperwork to comply with the requirements as to conditions in paragraph 22(1)(a). Well, again, that we say seeks to reduce the paragraph 22(1)(a) condition to a mere formality of paperwork. It's referred elsewhere at paragraph 87 of the appellant's case as a mere technical error. But I've explained the importance of that, or the importance at least that Parliament attached to that mechanism, which was plainly a proportionate requirement in the process of a person's release on bail. And indeed, there's no evidence before, well, one wouldn't expect evidence before this court, but no evidence before the courts below or adduced from any other cases to suggest that anyone did remain in detention as a result of this sort of defective order. And it wasn't complex. This wasn't a bureaucratic maze laid out at paragraph 22(1)(a) that a tribunal judge had to negotiate. There was only one precondition applied, presumably day in, day out, by a specialist tribunal. So the prospect, frankly, of would-be detainees, would-be bailees languishing in immigration detention because of failures of paperwork simply doesn't realistically arise. And if it ever did, there would be remedies such as judicial review and habeas corpus. So for those reasons, we say that Article 5 does not assist the appellant. My lords and my lady, those are my submissions on those two issues, unless I can be of any further assistance.
Oh, thank you very much, Mr. Duffy.
Thank you, my lord.
Well, I think then we return to Ms. Weston for her reply.
My lord, yes, I'm grateful. My lord, I have 7 points. If I could just, some of them are very short indeed, and if I could just deal with the last point first made by Mr. Duffy in his submissions. We say that the statutory, the strict construction point does arise in this case, and it does impinge on liberty, not least because the Secretary of State says that she would have been entitled to detain or not to release SM pursuant to the First Tier Tribunal's order. And so we say, of course, it's in play. And we would ask the court expressly to disapprove the approach taken by Lord Justice Haddon Cave in the court below, not least because the Secretary of State herself does not adopt it or seek to. That's my first point. My next point relates to the matters raised by my Lady Rose about what would happen in practice. We say, of course, there are no two systems of bail running in parallel. that's not what happens. The first tier tribunal is seized of bail and makes an order, contains the conditions which must be complied with on pain of being found in breach and possibly sent back to detention. There's no question about taking a risk on whether or not to abide by a set of conditions which have been provided in parallel. In practice, the Secretary of State, if the Secretary of State takes the decision to release on bail, the Secretary of State sets the conditions. If the first tier tribunal releases a person on bail, the first tier tribunal sets the conditions. In a case of where there's no appeal pending before the first tier tribunal, the normal order is, as described by the Court of Appeal in AR Pakistan, which is in the court's bundles, that on reporting to the immigration officer in accordance with the primary condition, it is then the immigration officer who formally sets the conditions. But as the point is made in AR Pakistan by the court, the immigration officer will not normally depart from those conditions unless there's been a material change of circumstances or there's justification, on pain of being challenged on normal public law grounds. So that's how the framework works, my lady.
What I'm not sure is whether you accept what was said that by the Secretary of State, that even when bail has been granted by the FTT, there is still a power in paragraph 2.5 of Schedule 3 to issue a notice of restrictions, at least if it's not inconsistent with the conditions attached to the FTT's bail? Or do you say that if the FTT has granted bail, that ousts the power in paragraph 2.5? Could you clarify that?
Bail is granted subject to the conditions only set by the first tier tribunal, and it's those conditions which govern the compliance for the purposes of bail, and not some additional, because bail has not been granted by the Secretary of State. It's been granted by the first tier tribunal. The question of, so for instance, we test it this way: would a breach of the Secretary of State's additional restriction notice result in being in breach of a bail order? No, it wouldn't. It's the first tier tribunal's bail order which governs the conditions attached to that bail. However, on reporting to the immigration officer takes over responsibility for the setting of conditions. They would normally be on normal public law grounds, following those of the first tier tribunal, absent justification for taking a different approach. And that was certainly the view of the upper tribunal. If we look at Mr. Justice Lane's judgment at paragraph 62 to 64, pages, my learned junior is just going to get the page reference. In the meantime, I'll go on to my third point, if I may. On the question of whether Parliament intended total invalidity to ensue from the nature of the error made in this case, we adopt the rationale and the approach. Indeed, my Lord Sales has referred to it in Soneji, and the reference for that is EF 1932. The particular page and passage reference is EF 1945 at paragraph 23, and we also rely on the J. Appellant decision, which begins at EF 1960, and we particularly rely on EF 1968 C to G. The consequences issue is articulated at 1964 E to H. The next point I wanted to take the court to was on remedy. It's wrong, we say, for the Secretary of State to say that this court isn't entitled to uphold paragraph 2 of the Upper Tribunal's judgment. And that is because whereas the Secretary of State is right to say that bail is currently granted under Schedule 10 to the Immigration Act 2016, by operation of the transitional provisions which are in the court's bundle, they are, that is bail by the tribunal and not bail by an immigration officer. And we see that from EF 979, which is the Immigration Act 2016 Commencement Number 7 and Transitional Provisions Order. And in particular, paragraph 1, which deals with persons at large on the date on which Schedule 10 comes into force, which was the 15th of January 2018. Subparagraph 4, if P, being SM in this case, has been granted immigration bail by a court or tribunal, then that bail is deemed to be a grant of immigration bail by the first tier tribunal under paragraph 1.3 of Schedule 10. So we say that it is appropriate, as at today's date, if the court's with us on our substantive points, to uphold the order of paragraph 2 of the Upper Tribunal. The next point I wanted to make was on the impact of Privacy International, and we're greatly assisted in this submission by the core submissions of the intervener at paragraph 7 little d. We say that the privacy isn't an answer to this case, because just because an order is a nullity for ouster clause purposes doesn't mean that it doesn't have to be obeyed unless or until set aside. My penultimate point relates to the Secretary of State's submissions on relative nullity. While it's right to say that relative nullity is not at the forefront of our case, nevertheless, given the direction of travel, and in particular I'm thinking of Lord Justice Singh in TN Vietnam, it's clear that the question of relative nullity arises in the context of a legal issue such as this. And we would simply point out that the intervener did in fact support and endorse our submissions in our statement of case on relative nullity, and we see that from the footnote at EF 194 in the intervener's written case, and in the intervener's core submissions note today, paragraph 7. The final point I wish to make relates to the Ashworth case, and it's worth turning up the Ashworth case because it's a good example of how the court treated the principle on which we rely, that the normal rule is that orders of the court which are found to be unlawful are nevertheless not void ab initio. And it's helpful to look at the sequence of events in Ashworth. So the EF page reference is 1594. So this was a case in which the a person detained under the Mental Health Act, Section 3, was discharged by the Mental Health Review Tribunal. That occurred on the 22nd of March of 2001. The hospital managers and the clinical and the clinicians disagreed with that decision and sought to re-detain him, and in fact did re-detain him on the 28th of March. And on the 29th of March, applied to the administrative court, and we see this in the facts outlined by Lord Justice Dyson at 1596, started judicial review proceedings against the tribunal relating to the rationality or the sustainability of the decision to order release. And then over the page at paragraph 3, 1597, we can see on the 4th of May 2001, the detained person started judicial review proceedings in which he sought to challenge as unlawful the recommendations of the clinicians, which had resulted in his admission, and the decision of the managers of Ashworth to readmit him on that date, on the 28th of March. So the issue, there were a number of issues before the court, but the issue with which we're concerned was the question of whether the hospital managers had been lawfully entitled to re-detain H before the point at which they had challenged the legality of the Mental Health Review Tribunal's discharge decision, in circumstances where they had subsequently obtained a decision from the court, an order from the court, that decision was flawed and unsustainable. And the Lord Justice Dyson was asked to find that the hospital managers had acted lawfully, effectively, because they were entitled to disregard, or acting consistently with, in the current nomenclature, the decision on discharge by the Mental Health Review Tribunal. And Lord Justice Dyson's reasoning on this issue, the key reasoning is contained at paragraph 54 onwards at 1610. So the normal principle, what's known as the von Brandenburg principle, is that absent a change of circumstances, it's not lawful to re-detain a person who's been discharged by the Mental Health Review Tribunal. And it was common ground that no such change of circumstances relating to H was applicable in this case. And we see that Mr. Plemming, therefore, the hospital managers, submitted that Lord Justice, Mr. Justice Stanley Burnton, he had been right at first instance to effectively say that the managers had acted lawfully. And then the substantive reasoning of Lord Justice Dyson is at 1611, towards the top of the page. The question of principle raised by this appeal is what steps are open to the mental health professionals and the hospital managers if they're faced with a tribunal decision for immediate discharge, which they honestly and reasonably believe is perverse or arguably perverse. Can they procure his readmission as was done in the present case, simply on the grounds that, acting conscientiously and honestly in accordance with their professional opinions, they believe that the tribunal's decision was perverse? Mr. Plemming submits not only that they can, but they must. In this way, the patient enjoys the full protection of the Act. If he wishes to challenge the hospital's decision to readmit him, he can do so speedily by a fresh application to a tribunal. He submitted that even if the court does have jurisdiction to stay the order of a tribunal, once discharge has taken effect, the Section 3 route, that's to say the Section 3 of the Mental Health Act route, is preferable to the grant of a stay. That's because if a stay is granted, the original Section 3 detention will be reinstated. And any challenge to the original detention is likely to be heard less quickly than a challenge for readmission. And the key reasoning is here, we say. It's true that in von Brandenburg, the court did not consider what the position would be if there were to be a judicial review challenge of the tribunal's decision. But Lord Phillips said emphatically that if there's simply a difference of view between the professionals and the tribunal, it's the opinion of the tribunal that must prevail. There is undoubtedly a tension between the need for certainty in respect to the rule of law and the duty on mental health professionals to perform their duties, and a simple difference of opinion between the two, that tension has been resolved in favour of the former. If the position were otherwise, it would be open to the professionals to subvert the clear provisions of Article 5.4. And then down the page, paragraph 56.
56 seems to be rather strongly in point, because that's dealing with the exercise of a statutory power to resection a patient.
Yes.
Done exercised inconsistently with the previous decision of the tribunal.
Exactly. So we say it is in point. Now we have to accept, and we do accept, that there is authority to the effect that the first-tier tribunal's jurisdiction on bail isn't coterminous with the Article 5.4 requirements. So to that extent, there is a slight distinction. But in substance, we say the rationale of the court here is plainly in point.
Well, Article 5.4 is only part of Lord Justice Dyson's page, just above letter B. I don't believe it should be possible to sweep aside so easily in respect of a rule of law.
Yes, indeed.
And the protection afforded to detained persons by Article 5.
Quite so.
Yeah.
So we place reliance on that approach by Lord Dyson, because it's an exemplar of the rule in a context which is relatively similar. That's to say, detention. Can I also, while we're here, also flag up the judgment of Lord Justice Simon Brown, which begins at paragraph 96 at 1624. He makes exactly the same point at 102, as indeed my Lord Reed has just made. And that's at, it's the second main paragraph on 1626. The effect of that decision seems to be plain enough, if I may respectfully say so, unsurprising. Where there's a difference of opinion between the MHRT and the hospital authority, the tribunal's view must prevail. The authority cannot simply overrule the discharge order. Court orders must be respected, and a key underpinning submission of ours is that the rule of law must be respected. My learned junior, to whom I'm very grateful, also points out that in Lord Dyson's judgment at paragraph 66, and I do apologise for not taking the court to it straight away, it's important to note at paragraph 66 to 68 that the errors of the tribunal were regarded by the court, which reviewed them as jurisdictional, and we see that in EF 1614, where? Where's this? That's not jurisdictional. Yes, I'm afraid I've misread my my learned junior's writing. What the court is noting here is that the tribunal's decision was perverse, and that's at the bottom of the. I'm not going to get into a discussion on whether, in anismic sense, that's jurisdictional. I don't think I need to. those were all the points I wish to make in response, unless there's anything with which I can assist the court further.
Thank you very much, Ms. Weston. Well, we're very grateful to Council for their submissions. We'll look forward to receiving the Secretary of State supplementary submissions within the next fortnight, and any submissions in reply within a week after that. And we will then get to work on this very interesting and important case. Thank you all very much. We'll adjourn now.